continuing where we left off, we started talking about the actors in the courtroom. So for part two, we're going to talk about some of the others. We started with the judge. So now we're going to take a look at the prosecutor. Obviously, it says plaintiff here. That's for a civil case. But prosecutor is the attorney who is going to bring the charges and try to find the accused guilty of whatever crime they have been accused of. They do work for the government on a state level, obviously, or on a federal level. They will be attorneys for that level. So when it comes to the prosecutor, the Office of the Prosecuting Attorney makes every effort, obviously, to hold the defendant accountable to their victims. And so they are going to try to charge what they deem is appropriate. That is all left up to the DA. I know in one of the things that one of the misnomers about police, they'll say, ooh, we can reduce the charges if you confess to something. That's just not true. The police have no control over what you're going to be charged with. They can make recommendations to the district attorney or the prosecution, but they cannot make the charges. That is entirely left up to the district attorney's office. We'll talk about that in a second. So it's the job of the prosecuting attorney in a criminal case to represent the interests of society, and that's why they work for the government. It is not individualized. One of the most missed questions that I've asked students in the past is, who does the prosecution represent? They do not represent the victim. Remember, they represent everybody because that criminal action has offended all of society. So they actually represent the collective interests of all citizens, and that's why they work for the government and not for individual people. What is the duties of the prosecuting attorney? Notice this, Kevin Steele. Kevin Steele is the district attorney for Montgomery County. He was the one who was responsible for prosecuting Bill Cosby. So that falls all under, anything that happens in Montgomery County falls under his jurisdiction. Now, he's not going to prosecute all those cases. He doesn't have the time for that. Notice that last bullet point, most cases will be tried by the assistant district attorneys. They are the assistant to the DA, and it's a stepping stone. Obviously, if you're there long enough, you step up to the, you could be the district attorney. District attorney is somebody who is voted in Pennsylvania. We'll talk about that on the next slide. So the DA has a great deal of discretion, remember our term discretion, about criminal matters. One, they're going to decide if an individual is charged at all. Maybe it's not a crime they want to pursue. Maybe they think that the police were a little overzealous. Whatever it may be, maybe it's not just worth their time. So they decide maybe we don't prosecute at all. Two, they're going to decide the level of charges that are brought. So is it going to be a second or a third degree misdemeanor or a first degree felony? Are we going to charge them with manslaughter versus murder? They're going to do the plea bargaining between them and the defense attorney. So all of that is done by the assistant district attorneys, ultimately signed off on by the district attorney themselves and the judge in the case. And maybe they decide to stop a prosecution. Maybe they find they have the wrong person. Maybe they find that their witnesses aren't credible, whatever it may be, and they drop the charges. Again, that's entirely left up to the district attorney or the assistant district attorneys, whoever prosecuting the case at the time. They will. So notice they have a great deal of power when it comes to this case of how it proceeds forward and what the charges are. And that's going to be very important in our case for Casey Anthony this week, because one of the big problems was, what do we charge the defendant with in that case, whether it be murder to or manslaughter. And that really does make a profound difference in the case and how it worked out. So in working the cases, most DAs are elected to the position. This is William Barr. Now, he's the U.S. Attorney General. He's appointed by the president, not voted in. The district attorney, like I said, in Pennsylvania, it's voted in. He would not be voted in. He'd be appointed by the U.S. Senate. Appointed by the president, sorry. The Attorney General is known as the top police officer in the United States. And they oversee the Department of Justice, if you remember. So one of the misnomers, and we've watched some Law & Order, and I really like Law & Order, and it's pretty accurate, but one of the problems with Law & Order is you often see the police working directly with the district attorney's office. And in reality, that's really not all that true. Now, while they do talk, basically the district attorney is going to read the reports of the police and go from there. They will interview them as witnesses, but there's not as much interaction as you see, and they do that because of time and try to get from point A to point B a little bit quicker. Also, there's a big difference in how the two work a case. Police officers will come from working class families. They're more of the hands-on people, and they are probably a little less educated than your obviously attorneys, who are going to be much more specific. Police work with what we call factual guilt. This translated is what we know. Remember, it's whether they committed the crime. The police are trying to find the bad guy. Who did it? Maybe why they did it, whatever else. But they want to know who did it. So they are going. That's their end game, is to find the bad guy and arrest the bad guy, and then let the DA follow up from there. So they're working with factual guilt, or what we know. And if I know that guy did it, then I'm going to arrest that guy. And as the police, I can do that. The DA, however, cannot work with that, or the assistant district attorney. They have to work with what we call legal guilt. And a lot of students get this messed up because they think facts are legal. Well, yes and no. While I may know something is true, that doesn't mean I can convince you that it's true. And so the DA has to work with facts that they can convince those 12 jurors sitting in the jury box that the person I'm telling you is guilty is guilty. And that is a lot harder. It's what I can prove in court. Now, that's where science has helped to some degree in forensics, because now we have DNA and fingerprints and go, this is the guy, or this is the woman that did this. We know it. It's provable. Unfortunately, forensics cuts both ways. A lot of times, jurors expect much more of this definitive stuff now than they used to in the past. In the past, a lot of times, police can work on what's called circumstantial evidence. Is if 2 + 2 should equal 4. If I have this fact and I have this fact, then this is the right person. That's called circumstantial evidence. And that means that it looks like an apple and it tastes like an apple, so it's probably an apple. Unfortunately, with forensics, people actually want to see the apple now. They want to know that it's the bad guy that we're accusing. And unfortunately, that's made the DA's job a lot harder. So knowing from factual guilt, or what I know, to guilt and what I can prove, has become a wide gap for jurors. And that's where the DA has struggled a little bit, trying to prove that the bad guy is really the bad guy. And again, that's very important for this week's homework assignment, because what you know, you're going to know a lot. What you can prove, that's a little bit different, and that's the hang-up that the prosecution is going to have in the Casey Anthony case. So this is very important to really keep in your mind when you're doing the questions this week, is what I know versus what I can prove. And that is a very difficult concept for most people to understand, and that's why when sometimes the bad guy gets away, people go, oh, it's the court's fault. It's the criminal justice system's fault. That's just not true. People are, we make mistakes. And if you have enough mistakes, they add up. We're going to see this later and again in a case later on this year, where mistakes just added up. And finally, the jury goes, there's just too many mistakes. And therefore, we can't find somebody guilty. So that's where the hang-up comes in. Now, on the other side of the bench is the defense attorney. And obviously, their job is they represent the accused person, specifically, and that's their only job. Some of the pictures you're going to see here are some of the more notable defense attorneys. If you watch Court TV, you'll see Mark Garagos on there. They've done a lot more high celebrity clients, and their job is to be the legal representative of the defendant. They have all these responsibilities in here. They're going to investigate the case. They're going to negotiate plea bargains with the prosecution. They're going to prepare for trial if they have to. They're going to submit motions to the court. The motion to the court is asking the court to do or not do something. Exclude evidence, allow this witness, stuff like that. Dismiss the case, whatever it may be. They're going to represent the defendant in the trial. Obviously, if they're found guilty, they're going to try to negotiate for a lighter sentence. And if there's an appeal process necessary, they're going to do that as well. Why do they get an attorney? Remember, going back to our Sixth Amendment, Ann Bremner, considered to be one of the better defense attorneys in the country these days. She's out of Washington, the state of Washington. Well, in the Sixth Amendment, remember, we have not only the fair and speedy trial, we talked about that before with due process, but you also have that right to the attorney. And the obligation of the defense attorney is to represent their client to the best of their abilities, despite knowledge of guilt or innocence. One question, if we were in class, I tend to ask students is, do you think that a defense attorney has a better job representing a guilty or an innocent client? And, I was even kind of surprised by the answer. I asked one of our defense attorneys, our public defenders, when I was talking to him, and I asked him that same question: is it easier to defend a guilty or an innocent client? Most people tend to think it's harder to defend a guilty client. Why? They're guilty. And Mr. Nestor, who's now, I believe, the head of the public defender's office, he just got appointed that a few months ago. He told me something different. He said it's actually easy to defend a guilty client, because if they're guilty and they're found guilty by the courts, you know what? They're getting what they deserve. They're getting the punishment they deserve because they committed the crime. He says much, much harder to defend an innocent client, because if a client is innocent and they go to jail, that means it's your fault and you have to live with that. And he goes, that's a very, very hard thing to live with. Now, a lot of attorneys will not ask their clients. They don't want to know whether their client is guilty or not guilty, because they want to provide the best defense that they can, and they don't want to be biased in any way. Or some will just always assume that their client is innocent and, defend them that way. Defense attorneys have bad reputations because they take cases, and they get find guilty people innocent. But if you ask them, they'll say, hey, if they were guilty and the jury found them innocent, then that means the prosecution didn't do their job. And so the defense attorney's job is to defend their client as best as they can. And the two types of defense attorneys we have are, of course, the private defense attorney and the public defender. Remember, in that Miranda right, if you can't afford one, you would get a public defender. If you can't afford one, typically Pennsylvania is, if you don't have a job, they're going to provide one for you. If you have a lower income, they'll have you pay a portion of that public defender's money. By the way, the movie myth that public defenders are all terrible attorneys is really wrong, especially here in Montgomery County. We have some outstanding public defenders, and they can do a very, very good job. And also the myth is that the high-priced defense attorneys will get their client out of any trouble. In fact, conviction rates for defense attorneys and public defenders are generally the same. The big difference is that when you have a high-priced defense attorney, their sole client is you, and they're going to spend all of their resources and all their time in your case. And if they have people that do investigation, they're going to all be dedicated to that. And I have the Simpsons defense dream team up here, because O.J. Simpson, in his case, paid a lot for these guys, and they did their job. They were all solely working on that case. With the public defender, they may have 10, 12, 15 cases at a time, and they're all sharing an investigator in their office, so they may not have the resources that a private defense attorney has, and they're working on other cases. It doesn't mean they're any less better an attorney, but it does mean they don't typically have the resources that your high-priced attorneys have. So that's kind of a myth that the high-priced attorney is always the better attorney. That's just not necessarily so, but it does mean that they have more resources. Final thing, when we talk about the attorneys, is this idea of attorney-client privilege. The attorney-client privilege is to promote communication between the attorney, and they share that. That means that, if in fact you do tell them, yes, I committed this crime, that the attorney cannot reveal that information ever. And this is so that if an attorney wants to know or needs vital information, that person, that defendant or the accused can share that information without having to worry about the attorney telling the court that they actually did it. Now, there are some exceptions to that. If the client gives permission, or if a third party is in the room and overhears it, that makes it a public communication. Or you cannot tell your attorney that, yes, when I get out of here, I am going after that prosecuting attorney. I'm going to kill them. Yeah, you can't do that. You can't admit to any future crimes. So this is the attorney-client privilege, and the attorney is not allowed to pass any of that information on to them. We've concluded with our attorneys. We'll finish up next segment.